Welcome to the Deep Dive. We want to challenge a fundamental assumption you probably hold about our justice system. When we think of the modern jury, the cornerstone of judicial fairness,
right,
we assume their job is pretty straightforward.
Right.
Listen to the facts, decide if the accused did the thing, and then apply the law exactly as the judge explains it.
Yeah, the standard view is juries handle facts, judges handle the law. Simple division of labor.
Exactly. But what if that's wrong?
Well, that assumption, it actually strips the jury of what many argue is its historic power. We're diving into a really radical historical principle today. It's got roots deep in the common law, and it was forcefully argued by the 19th century legal thinker Lysander Spooner.
And the claim is pretty explosive, isn't it?
It is. The claim is this. The moment a jury is told they can only deal with facts, they stop being a guardian of liberty. They actually become potentially a tool for government oppression.
Wow. Okay, so our mission today is to really unpack Spooner's defense of this older view of the jury's role. He laid it all out in his essay on the trial by jury.
And the core idea, it sounds simple, but it's revolutionary in today's context. Spooner says a jury's main duty isn't just judging facts or even like the moral intent of the person accused.
It's judging the law itself.
Precisely. Judging the justice of the law itself, acting as the ultimate popular check on government power.
So if juries don't have this power, this kind of popular veto,
then in Spooner's terms, they're just an instrument of the state. The whole idea of the trial by jury being the palladium of liberty, as it was called, it just gets corrupted.
So we need to explore why this jury veto was considered so essential, this barrier against government tyranny, and maybe, what happens when that power gets lost or taken away. Okay, let's start right at the foundation. Spooner uses this ancient legal term, trial per pe. What exactly does that mean, and why is that old phrase so important for his whole argument against government overreach?
Right, trial per pe. It literally translates to trial by the country, and that means trial by the people, by the community.
Not just some fancy old wording, then.
Not at all. It's really the philosophical centerpiece for Spooner. It defines the trial as belonging to the community, the people drawn from the local area, the vicinage. It's distinct from a trial held by the government.
That distinction feels huge. If someone throws himself upon the country, like they used to say, they're appealing to a standard of justice held by their peers, by the community's conscience, not just whatever rules the government, the political authority, has laid down.
Absolutely. Spooner argues that the whole point, the explicit historical object of having a trial by the country rather than a trial by the government is, and this is a quote, to guard against every species of oppression by the government.
Okay, so if that's the purpose,
then how can the jury possibly do that job if they aren't allowed to decide what the liberties of the people actually are, if they can't judge the justice of the law that the government wants to enforce?
That's the core logic. That's the indispensable check. If the government gets to tell the jury, here's the law, you must enforce it, no questions asked about whether it's fair or just,
then the trial isn't really by the country anymore, is it? It becomes a trial by the government. The government is measuring people's liberties by its own standard, its own laws, its own desire for power. It completely flips the script.
And Spooner really gets into the weeds here, doesn't he? He details the specific ways a government can control the process and turn the jury into, a tool.
Oh, yeah. He outlines with, frankly, chilling precision the mechanisms, how a government can keep the appearance of a jury trial, 12 people in a box, but completely destroy its actual substance, its protective function.
And it's subtle stuff, not always outright abolition.
Yeah.
First, he talks about jury selection.
Right. If the government controls who is even eligible to be a juror, it can just pick its own supporters, people known to favor its laws, its policies. It ensures compliance before the trial even starts. It's like stacking the deck.
A filter for independent thought, basically.
Exactly. But he goes further. It's not just eligibility. It's about questioning jurors before they're sworn in. The voir dire process.
Asking them about their opinions on the specific law.
Precisely. Spooner warns, if the government can question each person drawn as a juror as to his sentiments in regard to the particular law involved in each trial, and then kick off anyone who seems unfavorable, Well, the jury is basically guaranteed to uphold the law, just or unjust.
So imagine a really controversial law, maybe something restricting speech or property rights.
Yeah. If they can exclude any potential juror who thinks that law is fundamentally unfair or, unconstitutional in a basic sense, they've already won. They've pre-selected an outcome that favors the government's power.
And then there's the control over evidence.
Yes. Another huge mechanism of tyranny, Spooner points out. If the government dictates the rules of evidence, what the jury is allowed to hear and what they're not.
They can shape the whole narrative.
Totally. They can exclude evidence that might actually prove the accused innocent or show the government acted wrongly. Or, conversely, they could require a conviction based on flimsy evidence, whatever it pleases to offer.
That puts the jury in an impossible spot. They might feel in their gut that something's wrong, that the person is innocent or the law is bad.
But if the judge instructs them, you must consider this evidence, or you must disregard that evidence and you must apply this law as I state it, they're trapped. Spooner actually argues that for a jury to declare someone guilty under those conditions, knowing it's unjust, is an immoral and criminal act by the jurors themselves.
Because they're essentially acting as pawns, lending their legitimacy to an unjust act dictated by the government.
Exactly. The government uses the jury's reputation for fairness as a shield while actually controlling the result.
And all this leads up to what the essay calls the despotism principle. That sounds pretty serious.
It is. The despotism principle, as Spooner lays it out, says that the power to punish carries all other powers with it. Think about it. A government that can define what's illegal, command its enforcement, and decide the punishment, all by its own authority.
It answers to no one else, really.
It's above all responsibility for the justice of its laws. It is, by definition, according to Spooner, an absolute despotism, even if it has elections and looks democratic on the surface.
That's a massive claim. It suggests that just passing laws without some kind of check by the people on the justice of those laws is inherently tyrannical.
It does. He argues that if the only check is political, voting the lawmakers out next time, that's not enough. Because the harm is done now. The unjust law is enforced now.
Right. The election might be years away.
Exactly. The jury's right to veto unjust laws, in Spooner's view, isn't just a political preference. It's the essential legal mechanism. It's what prevents the government from having that final absolute say over life, liberty, and property. If the people give up that power, they've essentially signed away their freedom. Legally.
Okay, so to really get this idea, we need to go back. Way back. Spooner insists that Magna Carta, the Great Charter from 1215, isn't just some dusty old document. He calls it the true definition and vital source for understanding the jury's power. Why Magna Carta? What was happening back then?
Well, you have to remember the context. Magna Carta was basically a peace treaty forced on King John by rebellious barons. And in that system, the king was the government. Constitutionally, he held executive, legislative, and judicial power, at least in theory, and his judges. They were often just his employees, his abject servants, doing his bidding.
So the king could use laws and courts however he liked, for personal gain, for power.
Pretty much. He could use statutes, fines, judgments as tools to get money, land, loyalty. It could be incredibly arbitrary and oppressive.
So the barons, when they demanded this charter, they weren't trying to, politely ask the king to be nicer.
Hardly. Spooner argues their goal was to take individual liberties entirely out of the hands of the king and out of the power of his laws. They wanted a shield, a mechanism run by peers that would stand between the individual and the king's arbitrary power.
So if the jury was just meant to apply the king's laws to the facts,
the charter would have been useless. It wouldn't have restrained the king at all if he could still dictate the laws the jury had to enforce. That's Spooner's whole point about Magna Carta's intent.
Okay, let's break down that famous clause. Chapter 39. Everyone sort of knows it, but the wording is key. Nullus liber homo capiator. Nisi per legale judicium parium suorum, vel per legem terrae.
Right. No freeman shall be arrested or imprisoned or stripped of his rights or possessions, except by the lawful judgment of his peers or by the law of the land. But Spooner says, wait, look at the bit right before that, which often gets overlooked. Nex super eum bimos, nex super eum mitemos.
Okay, my Latin's rusty. What's the standard translation versus Spooner's, which he claims is the historically accurate one?
Modern translations might say something like, nor will we proceed against him, nor prosecute him. But Spooner, drawing on earlier charters and legal context, argues the proper translation is, nor will we, the king, proceed against him, nor send anyone against him with force or arms.
With force or arms. Why is adding those words such a big deal?
Because it fundamentally changes the king's role. It clarifies that the king's job here is purely executive. He's the muscle, the enforcer. He's promising not to use his physical power, his sheriffs, his soldiers, against a freeman unless that use of force has been authorized by the judgment of the man's peers.
So the king can't just decide someone's guilty and send the troops. The peers have to sign off first.
Exactly. The king isn't the judge. He's the guy who carries out the sentence after the peers have decided. It puts the judicial power squarely with the jury, not the king or his state judges.
Okay, that reframes things. Now, what about the judgment itself? Per judicium parium suorum, by the judgment of his peers.
This is maybe Spooner's most radical reading, but he insists it's historically sound for the time. He argues that in 1215, especially in criminal matters, the word judicium, judgment, wasn't just about guilt or innocence. It included the sentence, the punishment.
Wait, the jury decided the punishment too, not just guilty or not guilty.
That's the argument. Why? Because if the king, through his judges, still got to decide the sentence, he could still be oppressive. Imagine a harsh law mandated, say, losing a hand for stealing a loaf of bread.
Right.
The jury might think the law is barbaric. If they could only decide guilty or not guilty based on facts, they'd have to convict. But if they also controlled the sentence, judicium, they could find the person guilty of the act, but then assign a trivial punishment, like a small fine or nothing at all, effectively nullifying the king's cruel statute in that case.
So controlling the sentence was another way the jury could judge the justice of the law, or at least its application.
It was a crucial check on the king's power after the verdict. Okay, then there's legal judicium, lawful judgment. Spooner says this meant the judgment was given legally, following the proper procedures by the peers, and for a cause the peers deemed lawful according to fundamental justice.
It didn't mean lawful according to whatever statute the king just passed.
Absolutely not, according to Spooner. If it meant the peers just had to apply the king's latest statute, they'd just be a mouthpiece for the king, rubber stamping his will. The judgment had to be lawful in a deeper sense, consistent with fundamental rights.
Which brings us to the final leg. Vilial de leum terrae, or by the law of the land. What was the law of the land back then, if not the king's statutes?
Spooner, citing historical commentators like Coke, argues lex terrae meant the ancient, fundamental, unwritten common law of England, the established customs, traditions, and principles of natural justice that everyone understood, and that kings actually swore an oath to uphold.
So it explicitly excluded the king's new, potentially self-serving statutes.
Yes. That's the critical point. If lex terrae included any statute the king managed to pass, then Magna Carta would be, as Spooner puts it, sheer nonsense.
Because the king could just pass a law saying, I can arrest anyone I want. And that would instantly become the law of the land, making the charter's protection disappear.
Precisely. The whole point of the charter was to put the fundamental law, guarded by the jury, above the king's legislative whims. The jury, representing the country, was the keeper of that deeper common law.
Okay, so if we accept this premise, the jury is the ultimate judge of the law's justice, rooted in Magna Carta. The implications for individual liberty are, well, they're huge.
Mm-hmm.
What does this mean practically for someone facing a law they think is fundamentally unjust?
It grants the individual an almost startling level of sovereignty. Spooner argues it means any person has the right, the liberty, to disregard or resist any law, whatever, of the government, if he be willing to submit to the decision of a jury afterwards.
So you can break a law you believe is unjust.
And if 12 of your peers, judging the whole situation, the facts, your intent, and the justice of the law itself agree with you and acquit you,
then your act of resistance is essentially validated. It's considered legal after the fact.
Exactly. It's legalized resistance.
Yeah.
Your act of defiance is judged to have been justified, necessary even, against an illegitimate command from the government.
That's what separates free people from, well, subjects.
That's the argument. Spooner makes a really important distinction here between this legal right of resistance judged by a jury and the concept we hear a lot about, the right of revolution.
Right, the idea that people can overthrow a tyrannical government. Why does Spooner think that's not enough?
Because, he says, the right of revolution isn't actually a legal right under a government. It's a natural right that exists outside or against the government's legal framework.
The government itself never says, oh yeah, you have a right to overthrow us.
Never. And if you try and fail, you're punished, usually severely treason, sedition, you name it. The right of revolution is only really useful, Spooner says, for those who are already stronger than the government. It depends entirely on success.
Which means the government gets to define the terms, try to resist, Fail, and you're a criminal. Succeed, and you get to write the history books. It leaves a lot of room for tyranny to operate below that revolutionary threshold.
Exactly. It allows oppression to continue right up until the point people are desperate enough to risk everything in violence. Spooner argues the real security against every day, grinding tyranny, isn't waiting for a revolution, but having the ability to engage in forcible resistance to specific injustices and having that resistance legalized by a jury's potential verdict.
So, if there's no recognized legal way to resist bad laws without risking being branded a traitor if you fail,
then the people are effectively legal slaves, Spooner says. Their liberty depends entirely on the government choosing not to oppress them.
And the jury, with the power to judge the law, is the mechanism that provides this legal avenue for resistance. It's the independent tribunal, separate from the government, that can stand between the state and the individual dissenter.
And this is where Spooner makes a fascinating connection to another part of the U.S. constitutional framework. He points directly to the Second Amendment. The right of the people to keep and bear arms shall not be infringed.
How does he link the jury's power over law to the right to bear arms? That connection feels controversial today.
His logic is this. The Bill of Rights is clearly meant to protect individual rights against the government, not just against other private citizens. That's its whole purpose.
Okay.
So if the people have a right to keep arms, secured against government infringement, Spooner argues this implies a right to use those arms. Use them for what? Primarily, he suggests, to defend their liberties against government injustice.
And the jury fits in how?
The jury's power to judge the law provides the legal framework to determine when the use of those arms and resistance is justifiable.
I see. So bearing arms is the means, the tool for potential forcible resistance.
And the jury is the legal body that decides if that resistance in a specific instance was warranted because the government was acting unjustly or enforcing an unjust law.
So if someone forcibly resists a government agent enforcing a law, the jury deems tyrannical and the jury acquits.
They're essentially saying that person's armed resistance wasn't a crime. It was a legitimate act of self-defense against state oppression. Without the jury's power to judge the law, Spooner implies, the right to bear arms is effectively neutered as a check on government because any attempt to use them against the state would automatically be deemed criminal by the state's own laws and courts.
So the two rights, the jury's veto and the right to bear arms, are seen as interdependent pillars supporting liberty against potential government tyranny.
That's Spooner's powerful and, yes, very controversial linkage.
It seems clear, from Spooner's perspective anyway, that this powerful jury role was central to the common law. So the big question is, how did we get from that to the modern system where juries are explicitly told not to consider the law's justice, just the facts? How did this ancient power get, well, usurped?
Well, first, Spooner paints a picture of how justice worked even before Magna Carta. In the very old local courts, things like the court baron for a manor or the 100 court for a larger district, he describes them as being essentially mere courts of conscience.
Courts of conscience, meaning?
Meaning the juries, the local people deciding cases, weren't relying on a huge body of written statutes from the king. Those laws were few, often not even written down, and certainly not widely known.
So disputes had to be settled based on, what? Local custom? Yeah. Common sense.
Exactly. They decided cases based on their own notions of equity, their sense of natural justice and fairness within the community. The principles of law they applied were largely just their own ideas of right and wrong.
And this is reflected in the oath jurors took back then.
Absolutely. No. Spooner emphasizes the ancient jurors' oath. It wasn't like today's. They swore things like they would condemn no man that is innocent, nor acquit any that is guilty. And crucially, they swore to make known the truth according to their conscience.
What's missing from that?
Any promise to follow the king's statutes or the judge's interpretation of the law, their ultimate allegiance was to truth and their own conscience.
So if a judge presented a royal statute that the jurors felt was deeply unfair, maybe a new tax or a rule designed to confiscate property unjustly,
they were bound by their oath not to enforce it. They had to acquit the accused, finding him innocent of any real moral or lawful wrong, even if technically he broke the letter of the king's statute. Their conscience trumped the statute.
What about the judges themselves? Weren't they supposed to know the law? Did they just ignore the king's statutes too?
It's interesting. Spooner points to judges' oaths from around the 14th century. Judges swore to do equal law and right to everyone, rich or poor, and they explicitly swore to ignore any letters or orders from the king himself if those orders were contrary to the law.
Contrary to which law? the king's own statutes.
No, contrary to the fundamental common law. Spooner takes this as strong evidence that even the king's own judges were supposed to recognize that royal statutes were invalid if they violated basic justice or the established rights of Englishmen. The common law was supreme.
Okay, so if both juries and even judges were originally supposed to prioritize fundamental justice over arbitrary statutes, how did it flip? How did we get the modern idea that judges declare the law and juries just find facts?
Spooner argues it was a slow, deliberate process of judicial usurpation. He absolutely condemns the modern maxim ad questionum juris respondent judices, ad questionum facti respondent jurators, judges answer to law, juries to fact. He calls it an invented maxim.
Invented by whom?
By the judges themselves. He says it doesn't come from Magna Carta or ancient constitutional principle. It expresses only the ambitious and lawless will of the judges themselves, wanting to grab power from the jury, from the people.
Why would judges want to do that? What's the motivation?
Spooner sees an inherent conflict of interest. The judiciary, like the executive branch, is usually dependent on the legislature, or the ruling power, for appointments, salaries, budgets. This dependence, he argues, is a guarantee that they will always sanction and execute its laws, whether just or unjust.
They're part of the permanent government structure. Their interests aligned with maintaining state power.
Right. Their careers, their status, it's all tied into the system. But jurors...
They're temporary. They come from the community and go back to it.
Exactly. Jurors aren't beholden to the government for their jobs or future prospects. They have to live under the laws and the precedents they help establish. Their accountability is to their neighbors, to the country, not to the state apparatus.
So their temporary nature is actually their strength, their source of independence.
Precisely. That makes the jury the only truly independent check, in Spooner's view, capable of standing against the combined power of the permanent government branches, legislative, executive, judicial. Once the judges manage to convince everyone, including jurors themselves, that juries should only deal with facts, they effectively disarmed the people's most potent legal shield against tyranny.
This brings us to what might be the most challenging part of Spooner's argument for modern ears. He claims that true trial by jury disavows the majority principle altogether. I mean, we live in democracies where majority rule is almost sacred. How does he justify rejecting that?
Well, he challenges the core assumption that just because a majority wants something, it automatically makes it right or gives it the force of legitimate law. He sees that as just a more sophisticated version of might makes right.
His line is something like, two men have no more natural right to rule one than one has to rule two.
Exactly. For Spooner, justice is based on natural law, on reason, on individual rights. Those things don't change based on how many people vote for or against them. Numbers don't determine morality.
So when a majority uses its power through legislation to, say, impose unfair taxes or grant special privileges to one group, or put arbitrary limits on trade that benefit them,
Spooner says that turns the nation into a great gambling establishment. People's fundamental rights, their property, their liberty become the stakes in a political game. The minority is constantly at risk of losing their rights simply because they lost the latest vote.
And the jury system, in its original form, according to him, is the ultimate protection against this tyranny of the majority.
Yes, precisely because of the unanimity requirement. It takes 12 randomly selected people representing the country and requires all 12 to agree before the government's force can be brought down on an individual.
12 votes needed to convict.
Which means the minority, even a minority of one, if they can convince just one juror, has an absolute veto over the majority's unjust law in that specific case.
If just one juror, listening to their conscience, believes the law itself is unjust or that applying it in this situation would be oppressive,
they are bound by their oath, the ancient oath anyway, and their duty to fundamental justice to refuse to convict, to hold out for acquittal. And if they do, the government's law cannot be enforced in that instance. It's blocked.
That inability to reliably enforce unjust laws is what really limits the legislature's power then.
That's the idea. Spooner argues that legitimate government can only arise from voluntary association, where people agree to band together for common purposes. They all consent to mutual defense and the administration of justice. If the government passes a law that violates that fundamental sense of justice,
the jury, representing the whole people or a cross-section, is expected to withhold its consent to enforcement. They effectively say, no, this isn't what we agreed to.
Right. And Spooner ties this directly to that other great pillar of historical English liberty, no taxation without consent.
How are trial by jury judging the law and no taxation without consent linked.
He sees them as mutually essential, reinforcing each other. If a government tries to impose taxes on people who haven't truly consented to pay them, Spooner says that's just robbery. It doesn't matter if it's one highwayman or millions calling themselves the government.
And a jury operating under the principle of judging the law as justice
Would refuse to convict someone for resisting such a tax. They'd see it as enforcing robbery and refuse to participate.
And the flip side, if the government can tax people without real consent,
Then it gets the money, the power, the force needed to bypass the jury. It can fund its own standing armies, its compliant judges, its bureaucracy. It can build the machinery needed to crush dissent and eventually replace the people's jury with its own tribunals. Liberty is lost.
it's like a feedback loop. Control over the purse strings and control over the jury's power are intertwined.
Absolutely. He even extends this to the cost of justice itself. If the government makes people pay fees just to access the courts to defend their rights and then fails to deliver actual justice,
The government becomes part of the problem, an accomplice to the wrongdoer.
yes, the citizen is essentially robbed of the means to get justice. Spooner argues a true jury, judging by natural right, would acquit anyone who used necessary force to resist injustice if the government had effectively denied them a fair and free path to legal remedy. The jury's power becomes the ultimate backstop, ensuring the government can't just ignore its fundamental duty to provide justice. Hashtag outro.
Wow. Okay, so this deep dive into Spooner's essay, it really paints a picture of the trial by jury that's radically different from what most of us experience or understand today.
It really does. It wasn't just about sorting facts. It was designed, he argues, to make the people the ultimate sovereigns over the law itself. The absolute bedrock guarantee was that no government punishment, no enforcement of a law could happen unless it be concurred in by both court and jury, with the jury having the final say on the law's justice.
And the implication, if that original power, the jury's power to judge the law, were somehow fully restored today.
Spooner's pretty clear. The scope of government legislation would shrink dramatically. It would become exceedingly narrow. Why? Because any law that violates natural rights, especially the rights of minorities, things like monopolies, special favors for corporations or unions, arbitrary restrictions on business, non-consensual taxes, they'd all be effectively nullified.
Because juries just wouldn't enforce them.
Juries, guided by conscience and natural justice, would simply refuse to convict people for violating them. They'd see them as illegitimate.
So what kind of laws would survive?
Spooner contends that only laws dealing with clear intrinsic wrongs, murder, theft, assault, things about which there's already a strong natural consensus would likely stand. The huge, complex web of modern statutes, often contradictory, often serving special interests.
That maze of written statutes, as he calls it.
Much of it would just become unenforceable, irrelevant. Because, as he concludes, if you ask anyone honestly what they want in court, they want their case judged on principles of natural justice and right, not buried under legal technicalities or arbitrary rules.
Natural law, he believes, has a moral clarity that statute law often lacks.
A certainty, yes.
It definitely leaves you thinking. Considering how much modern law does involve complex regulation, economic controls, things that aren't straightforwardly about harm, what would our legal system, and really the power and reach of our government, actually look like today if 12 ordinary citizens, bound only by conscience, truly held an absolute veto over every single law?
That's the provocative question Spooner leaves us with, isn't it? It forces us to ask whether our current system truly serves justice, or if perhaps it mainly serves the power of the state that writes the laws.
A lot to chew on there.
Well, that's about all the time we have. You've been listening to The Deep Dive from Wake Up and Smell the Freedom, where ideas percolate. Thanks for joining us as we continue to explore the ideas that shape liberty and continue to shape us today. Remember, the pursuit of liberty begins with understanding, and understanding begins with asking the right questions. Until next time.
Bye-bye.